time for the Law and You segment, sponsored by Gig and Jancola. Join with us now. We've got attorney Michael Gig and Christopher Jancola.
Yes, good morning.
Good morning, you guys. Talk about the law that you practice.
Yes, we do a lot of stuff. Yes, we do wills, trusts, estates, and real estate. And I do personal injury, workers' compensation, Social Security, disability.
All right. Yeah, a lot of buzz, too, around these topics. People, of course, can write in different questions, and you break it down, kind of bust up the myths that we hear, some of the rumors, too, or, you know, even just debunking things that people have access to, like on the internet or different scams, because unfortunately that does come with the territory.
Yes.
Mike, you break down a lot of details, of course, on wills, trusts, estates. Today we're going to be talking about what a living will is all about.
Yeah, I pose this question because it comes up a lot with people. So living will, a lot of people, first of all, living will has the term will in it. They think that's also your will. It's completely different. It's almost a misnomer, the term. A lot of people call it an advanced healthcare directive. So basically what it is a very, very, very specific document. It's only for end of life treatment decisions and preferences. So it only is in two unique circumstances. Both situations, you're in a terminal state, okay? So end of life. One, you're in essentially a conscious state. One, you're in an unconscious state. So I usually say about 98% of the time these come into play, you're in an unconscious state. So it's some type of persistent vegetative state, you know, irreversible coma. The normal situation is, because we have clients come in and say, hey, my mom or dad's at the hospital in palliative care, you know, do they have I think, you know, they have a living will with you guys, do you have it? So it's usually a situation like that, where they're at the hospital, perhaps a nursing home, and they're, you know, in an unconscious state. The other one is, you know, you're still in a terminal condition, but you are conscious, so you're awake, but you've been declared to be legally incapacitated or incompetent, so you can't make medical decisions for yourself. So a lot of times, I use the example of, it could be someone with, you know, stage 4 cancer of some sort, but also like advanced dementia or Alzheimer's. Those are more unique, but still it comes into play. So living will is just a document that says, hey, if I'm ever in one of these states, I'm making my wishes known now of what types of treatment I do or do not want, because at that time, of course, you won't be able to make those known. But it's a very specific document. I try to stress that it's only in those end-of-life situations. Your power of attorney, if you have one, which we always suggest you should do that, it's never too early to do that. That's who would use this document to provide, you know, the hospital or nursing home. But it's really to help your family too, so they don't have to, you know, make these decisions, you know, themselves. They know what your wishes are.
So say you are, you know, never going to recover or get better, right? You're in that incapacitated state. Can somebody create that on your behalf, or would that need to be set up? So really you need that before even,
So a power of attorney can't do a living will for you after you're incapacitated. They can't change your actual will for you. They can do a lot of things, in fact, most things for you medically and financially, but they can't create a living will. That's something you have to do while you have capacity. And that's why we always say it's never too early to get these things done.
Yeah.
Because we oftentimes, you know, unfortunately, we get the situations where maybe it is too late, or their loved one is kind of, and that's where it's an ethical part on the attorney, that are they really competent to do it? You face those, if you do this type of law, you face those kind of ethical dilemmas a lot. You have to make sure that they have capacity to sign a document, especially like this.
There's so many situational based circumstances with you guys. Of course, we talk about that because it makes me think, okay, obviously there's different types of wills and obviously a trust and estate, like setting things like that, establishing that. But it's like, well, who needs what at what point in their life? And that's kind of where you have to determine and assess what's best for people.
Yeah, I mean, any time now, I say, even if you're younger, have a power of attorney. You know, a lot of times if you're married, name your spouse. And maybe your kids are still minors, so you can't name them, but because anything could happen, you know. And even a living will, to be honest. I mean, because anything can happen. Accidents happen, and you could get into that state. So anymore, I tell people, if you're looking to do your will or update your will, and you don't have like a living will or a power of attorney, they're not they're not that expensive, and they can really help your loved ones later on, because you
Right.
don't know what can happen.
Yeah.
And you don't have to think about it again.
Yeah.
Once you
That's-
get
yeah.
the documents, unless something changes in your life.
Yeah, all about the planning, putting that in place. If people want to reach out to you guys, what's the best way to do it?
Give us a call at 814-946-1606 or go to gig-law.com.
All right. Thanks so much, Mike and Chris. Coming up from